Well, hello there. I'm Gemini.
Hello and welcome. Today, we're going to dive into a story that's part legal thriller, part business masterclass. It's about a single Supreme Court case that completely rewrote the rulebook between Canadian taxpayers and the tax authority. Now, this isn't just some dry legal history. It's a high-stakes battle over a question that every single entrepreneur has to face.
So let me ask you this. Picture it. You've poured your savings, your time, maybe even your sanity into a new venture. It's losing money at first. I mean, what new business doesn't? So the question is, can the Canada Revenue Agency, the CRA, just waltz in, look at your red ink, and say, nope, sorry, this isn't a real business. It's a hobby. For decades, the answer to that question was a terrifying, you bet they can.
So here's our game plan for today. First, we're going to meet the profit police and understand the old world they operated in. Then, we'll get right into the thick of it with Brian Stewart's condo battle. After that, we'll see the epic Supreme Court takedown that changed everything. We'll break down the brand new test they put in place, and finally, the part you've been waiting for, we'll unpack exactly what this all means for you.
All right, let's set the stage. Before the year 2002, if you were a business owner in Canada, things were, well, they were different. The CRA had this incredibly powerful tool in their back pocket, and frankly, it created a constant cloud of uncertainty that hung over pretty much anyone trying to start something new.
You were basically living in this murky, gray area. Think about that for a second. You could follow every rule. You could file your taxes with absolute honesty, but you were never, ever truly safe. The CRA had this power to just come in, look over your shoulder, and challenge your legitimate business losses based on their own subjective opinion.
And this was their weapon of choice. The Reasonable Expectation of Profit Test. We'll just call it REOP. An auditor could just look at your business, especially if it was losing money, and decide if you had a reasonable expectation of turning a profit. And if they decided you didn't, well, then they'd declare your venture wasn't a real business, and poof, all those startup losses you were relying on to offset your other income, they were just gone, vanished into thin air.
This quote just hits the nail on the head, doesn't it? It perfectly captures how lopsided things felt. The REOP test made it feel like you were playing a game where the other team not only had the secret rulebook, but all the referees were on their payroll too. It was vague, it was arbitrary, and it was incredibly tough to argue against.
But a system this tilted, this heavily weighted in favor of the taxman, well, it was bound to face a major challenge eventually. And that challenge came from one determined man who decided to fight back. Let's dig into how one person's battle changed everything.
And that brings us to the man of the hour, Brian J. Stewart. Now, his case wasn't some hobby farm or a weekend passion project. No, this was a pure, cut-and-dry commercial investment that put him on a direct collision course with the CRA and their all-powerful REOP test.
Okay, so let's get into the nitty-gritty here, because the details really matter. Back in '86, Stewart buys 4 condos to rent out. He uses a ton of leverage, only puts $1,000 cash down on each one. And here's the kicker. His own business plan, his own projections, showed he was going to lose money for about the first 10 years. Why? Mostly because of the massive interest he was paying on the loans. So from 1990 to 1992, he did exactly what you'd expect. He claimed over $58,000 in legitimate business losses.
And you can probably guess what happened next, right? The CRA saw those projected losses and brought down the hammer. They pulled out the REOP test and said, look, this guy doesn't reasonably expect a profit for a decade, so this isn't a business. It's not a source of income. And just like that, they disallowed every single penny of that 58 grand.
So the fight began. And let me tell you, this was not a quick legal spat. Look at this timeline. We're talking about a marathon, an incredibly expensive and draining fight. Stewart fought the CRA's decision, and he lost. He appealed to the tax court, and he lost again. He took it even higher, to the Federal Court of Appeal. And guess what? They also sided with the CRA. For more than a decade, the system defended REOP at every single turn. But Stewart, he refused to quit. He took his fight to the last stop, the Supreme Court of Canada.
And this, right here, is the moment everything changes. After all those years of fighting, of losing, Brian Stewart's case finally landed in front of the 9 justices of the Supreme Court. This was it. The stage was set for a decision that would send absolute shockwaves through the entire Canadian tax world.
Go ahead and circle this date on your calendar, May 23, 2002. This is the day the Supreme Court handed down its verdict and, in doing so, basically took a sledgehammer to decades of tax law related to business losses.
Now, this is so crucial. The Supreme Court didn't just disagree with the CRA's math. No, they attacked the very foundation of the REOP rule itself. They basically said the test had become a weapon for the CRA to play Monday morning quarterback, to judge business decisions with the perfect 20/20 vision of hindsight, a luxury that, no real entrepreneur has when they're making a bet on the future.
And with that, the knockout punch. In a stunning, unanimous decision, the court sided with Brian Stewart. They allowed his losses, and in a single, powerful judgment, they declared the REOT test was no longer valid. The doctrine of REOTP was dead, gone, finished. The era of the profit police was officially over.
But, the Supreme Court didn't just smash the old system and walk away. That would have created chaos. Instead, they built something new in its place, a logical, objective, and frankly, much fairer test for figuring out what actually counts as a source of income. And here it is, the new two-stage test. And honestly, it's beautiful in its simplicity. Step 1, you just ask, is this activity commercial or is it personal? Is it a business or is it a hobby? For something like Stewart's condos, where he wasn't living in them, the answer is obviously commercial. Once you've established that, you move to step 2, which is, there really isn't a step 2 for a purely commercial venture. If it's commercial, it's a source of income. Period. The end.
Just look at this side by side. It's night and day, isn't it? We went from a vague, arbitrary test that used hindsight to second-guess your business smarts to a clear, objective standard that asks one simple question: commercial or personal? The new way actually respects the risks and decisions business people have to make.
And just to make sure the CRA really got the message, the court wasn't done. On the very same day, they dropped a companion ruling in a case called Walls v. Canada. And this one was a big deal because it involved a tax shelter, which for years had been the #1 target for the old REOP test.
Now, get a load of these numbers, because they're wild. The partnership in the Walls case bought a mini warehouse for almost double what it was worth, and they claimed a ridiculous 24% interest rate on the financing. This thing was a tax loss-generating machine, and it was designed that way from the start. Under the old REOP rules, this would have been an open and shut case for the CRA, but under the new test, the court said it didn't matter. The activity, running a mini warehouse, was clearly commercial. The fact that the motive was tax savings was completely irrelevant to that basic question.
Okay, so we've walked through the history, the epic legal battle, and the new rules of the game. But let's get down to brass tacks. The most important question is, what does the death of REOP and the birth of this new test actually mean for you today as an investor or an entrepreneur?
Let's break down the 5 biggest takeaways, because this is where it gets really practical. First, interest deductibility. This is huge. Interest is now fully deductible as long as just one of your purposes is to earn income. So you can buy a rental property mainly hoping it will go up in value, and even if you're losing a bit on rent each month, that big mortgage interest bill is still deductible. Second, capital gains. The court officially said that trying to make a capital gain is part of the pursuit of profit. This was a massive win for investors. Third, tax shelters. The CRA lost its biggest, bluntest weapon. They can no longer just say no REOP to kill a shelter. They have to use other, more specific anti-avoidance rules. Fourth, the CRA's power. Their job fundamentally changed. They are no longer the judges of your business plan. Their job is simply to ask, is this a commercial activity or a personal one? That's it. And finally, taxpayer motivation. The Walls case carved this in stone. Being motivated by tax savings doesn't matter, as long as the underlying transaction is a legitimate commercial.
So yeah, the Stewart decision was a monumental victory for taxpayers. It was a total game changer, replacing a subjective, unfair system with a clear, objective standard. It fundamentally redrew the lines of power. But this dance, this ongoing tug-of-war between taxpayer rights and the government's need to collect tax, it never really ends. So the question that we're left with is, where will the line be drawn next?